Okay, everybody.
And Murphy is in.
Welcome to the Asset Positioning Services class of the week. I'm Randall Baxter. I'm the president of the company. And I hope everybody's comfortable and ready to go because this is going to be a pretty detailed meeting today, but some pretty serious things that we need to talk about. And the topic is going to be the end user agreement. And I get a lot of questions about it. People don't understand it, and some people don't use it the way it could be used. And we'll try to cover those topics today too. So the end user agreement is what we're going to be doing. So, it's important to understand what you're selling. And what I have found is that not all licensees understand exactly what they're selling. And at the end of this meeting and after people listen to it, I hope that problem will be solved. But you're a better advisor if you understand the retail end user agreement. It helps to understand the true purpose and function of Family Estate Doc software in the estate planning process, because actually people can buy the license to use this software without any advisors to be involved. The do-it-yourselfers love this software, and it's sort of designed for the do-it-yourselfer. And the way we get involved, we come in as coaches and advisors, not as lawyers, and we're helping this person use their do-it-yourself software. So what we need to do today is we're going to review the retail end user agreement. I'm not going to read all the legalese to you. I'm just going to hit the basic high points, but you owe it to yourself to go in and read that agreement. Your client has to say that they accept it before they buy it. But you know what? I don't think more than 1% of people ever read it. But they are saying yes, they agree to it when they use the software. So I think it's really, really important, excuse me, that you have read it so that you can answer any questions that they have. But you have that responsibility. So anyway, the end user agreement is commonly called the EULA, the end user license agreement. And it's a legal agreement between the purchaser and Family Estate Docs for the use of cloud-based software applications. And that's important that you understand. You got to have that distinction. You have to understand that. So by using this product, the Family Estate Docs product, you agree, and I'm talking to the retail person right now, you agree to be bound by the terms that we're about to talk about. They're pretty serious. You need to understand them. So if you had to describe the software is actually a self-help software. And it enables the client to use do-it-yourself products. Now, most of the time, I'm helping the client get it done. But they want me to help them, and they could do it themselves, or I could say, hey, go in and do this yourself. And a lot of our licensees, when they sell the product, they send them the link and say, do it yourself. They're missing out on the back-end sale if you let the client just do it themselves. So the real issue in the software and between the software and the licensee, and this is important, the issue is how involved should you be in the process? I mean, everybody's got a different opinion of that, but the software is updated occasionally, and it's important that the client information be kept up to date. So I highly want to encourage you, if you are a functioning licensee selling this on the retail level, that you at least schedule an annual review with your client. Because we all know, and you've heard me say it 100 times, assets change, relationships change, and health changes. And I'm also, you've heard me say this 100 times too. Every time one of those events occur, I can almost promise you money starts moving around. And those people want advice on that money. So the end user, the retail person who's bought this estate plan, that person is the end user. And the end user is granted a license to use the software. They're not sold the software, they're granted the use of the software. And that's different. That they're buying an estate plan, but they're being granted the use of the software for their estate plan. It's a pretty big difference, isn't it? So the Family Estate Docs licensee awards the user, the retail person, access as a single user. It's the licensee who has the responsibility of communicating with the end user. So if you're one of the Family Estate Docs licensees, that's your job. That's not the software's job. Now, I'm going to say that again. The Family Estate Docs licensee awards the user access as a single user. When you charge them the $19.95 or whatever fee you charge, you are giving that person becomes a licensee who has the responsibility. Well, you're the licensee, but they are the end user. It is the licensee who has the responsibility of communicating with the end user on how to do it. And that's where the relationship is established. Probably going to, and I'll be honest with you, and I don't care to say this to you, you make a whole lot more money working on the back end than you do on the front end in the estate planning process with the software. And that does require communication. So the retail buyer, which is also called the end user, agrees to use the self-help software. That's what they're agreeing to access the do-it-yourself estate planning legal forms. There's my weekly misspelled word. Creating one legal document for each product you select. You get a pour-over will, a power of attorney for finances, power of attorney for health care, advanced care directives, and you get a revocable trust. You get one. So you can't buy it once and then go in and change all the names and do it for your neighbor. That's not what the license says. But corrections are allowed. You can go in and make corrections. That's why you can't always change the name on the trust that you write it or the date. That keeps people from buying it once from you and then spreading it around with the whole neighborhood. So the end user permission is granted for personal use and not commercial use. As a licensee, you have the permission for commercial use, but the end user who buys it, they don't have commercial use. They just have personal use. And the end user agrees not to copy the documents for the use of others. And like I said, people don't read it. They don't read their end user agreement. But this is something they're agreeing to. They're agreeing not to print it off and mark the names out and put new names in and sell it or give it away. So the end user has to understand, and in the form on the end user agreement, it says they do understand. I'm going to be honest with you, and I'm going to tell you, I'm not sure they understand because I think they just say I agree and don't read it. But the end user understands that the software, the Family Estate Docs software, is not a law firm. It's software. You are representing yourself and are free to consult with an attorney. You don't have to, you have attorney written software. But when I say you are representing yourself, we're not talking about you, the licensee. I'm talking about the retail purchaser. So the end user agrees to be responsible for selecting and preparing the documents and may seek their own counsel and advisors. They have sought you out as one of their advisors, or you have sought them out and convinced them to let you be one of their advisors. We keep an attorney on staff here involved in our business for questions. And then we have attorneys at the home office for questions. But the software is not an attorney. So this is what the end user agrees to. They agree to select the appropriate forms. They agree to provide the proper spelling and grammar. They agree to obtain proper advice if they need it. And they agree to be sure that the wording is correct. They agree to apply the law to their own circumstance. And they agree to determine the legality of the information. And they know that if they want to, they can seek legal counsel. There's a second misword on the same word. I've misspelled legal twice, two different ways. To seek legal counsel if desired. Do they need to? That's up to them, because everybody comes from a different direction. Everybody's got different sets of knowledge. So you got just to say it again. This is self-help software. If I buy it and it's not appropriate for me, that's my fault. That's what this end user agreement said. Some people don't need a revocable trust. Some people need something else. So what we're saying here is no financial tax or estate planning advice is provided. Seek your own counsel. So yeah, I'm sorry, folks. I did this early this morning, so that's 4 little misspelled words in there. But so what they're talking to the end user, the retail purchaser, is you can use this software if you choose to, but you have to be responsible for what you create. We will provide, as a company, Family Estate Docs, we provide attorney written documents, but we are not giving you the attorney's advice. I'll let you ask questions here in a minute. But anyway, the document propriety is guaranteed. And I'm in Tennessee. I know that if I want a Tennessee document, I'm going to get a legal Tennessee document. If you're in Maryland or Texas or wherever, you're going to get a document that's appropriate for the state that you choose. In each state with an attorney written document is applicable to the individual states. That does not mean that person is purchasing the right document. Because a lot of people think that when they're buying a revocable trust, they think they're buying a Medicaid planning trust. Well, they're not. Or they think that they're buying an asset protection trust. They are not. So if you use self-help software, you have to know that what you're doing is the correct thing to do. That's why people seek advisors. So there's no guarantee the Family Estate Docs or Estate Docs Pro or whoever, there's no guarantee that the products will apply to your situation. You have to have an advisor to help you do that. Or you can make the decision on your own. That's what you're agreeing to as a retail person. That's what you're selling as a licensee. Future updates are not guaranteed, although they're very Estate Docs Pro is very good at it. They update their products all the time. Okay, but there's no guarantee that there'll be an update that's appropriate for you when you go into the software and seek to change it. The update might occur 48 hours later. So there's no guarantee on the updates. But you do have Vault Access guaranteed for 1 year. I don't think any of you have seen that fee applied yet, but there is an annual subscription for the Vault, and that's the $29.95. So, if you don't pay it, you don't have, it'll still be in your vault, but it won't be guaranteed. You won't have access to it. When you do the self-help software and go in and it says this is the legalese is printed out, changes to wording are not allowed. So if you go in and try to change the wording, the computer software will kick you out. You can do restatements. Those are allowed. Amendments must be done by an attorney. So the biggest thing is that you need to understand the difference between a restatement and an amendment. An amendment is where you go in and change a section of the trust. Let's say section 4.1, where you're naming beneficiaries. Okay. If you only want to change that one section, that's an amendment. You can still change 4.1 if you want to on this software by you doing a restatement, and you go in and you change the section that you want to change, and then you print the whole trust out and get the whole trust renotarized and rewitnessed. That's a restatement. That's one of the advantages of this do-it-yourself software is you can restate older trusts. But if you just want an amendment, or if there's some unusual situation in your life that you need a special kind of wording, we can get the trust amended, and that usually costs about $200. But usually that's only if you're changing the wording. If you just need to change the answer, you can do a restatement. So you need to understand how that software works. But you know what? Actually, the purchaser, the retail purchaser, is responsible for printing and shipping. We had to talk about that in the business meeting this morning. I don't care to tell you, I always print the estate plan out for my client. Always. Because it's just a service but I don't have to. The end user agreement says that I can sell them the license, and then they have to be responsible for printing and shipping. When you help one of your clients get the Family Estate Doc software, they are agreeing that the purchase is for their personal use and not for resale. You're the wholesaler as the Family Estate Docs licensee. The purchaser, the retail person, they click I agree, and they're not reading it. But what they're agreeing to is that the purchase is for their personal use and not for resale. So the software is protected by law. It's copywritten material. And Family Estate Docs retains all the rights to the wording in the software. The retail person also agrees to arbitration. If they say, hey, I'm not happy with this, what they're agreeing to in advance is that it won't go to court. It'll go to legal arbitration, not a courtroom. Written notice of the dispute is required, and it's governed by the Federal Arbitration Act for Arizona. The reason for that is the software is all based in Arizona. So your client that you've sold a trust to has already agreed to this, but they probably didn't read it. So there's a limited liability to the actual amount paid by an end user. So if an end user pays $19.95, then that's the maximum liability that you have as the licensee. As far as responsibility goes to the retail buyer. And why is that? It's because it's claimed in the end user agreement. And then before the end user retail buyer can even start answering the questions, if you look at your screen, there's a little button pops up and it says, do you agree to the terms of this agreement? The end user accepts all terms to the agreement. If they don't accept the terms of the agreement, it won't let them put the information in. So what what I've been saying to you is this presentation is intended as a review, and it's not all inclusive of the end user agreement. If you want to understand it, you need to go to your web page and pull it up and read it, because I condensed the wordage down to probably about 10%. I'm just
May I
trying to
ask a
tell you what
question,
it
Randy?
says. Yeah, go ahead.
On the, of course, them agreeing to the end user agreement, I have a question, it's like, if you've actually presented to the people, then you use use your form where you're saying, hey, I'm going to act in a secretarial capacity to do this for you. It's like, how do you handle the fact that when you actually are, log into their plan, it's like, who's actually accepting the end user agreement in that situation?
Well, they share that information with you, and when you log into their plan, if you change something, they still have to sign it. They still have to have it notarized and witnessed.
Well, no, what I was talking about is at the very beginning. It's like the situation, like sold the plan. They said, hey, yes, we want you to act in the secretarial capacity, inputted everything in based on our interview, then we'll review it after the fact. Well, to actually start putting information in, the end user agreement has to be checked and accepted, but they're actually not, looking over your shoulder while you're doing that part.
Well, Tony, let me think about that a minute.
Yeah.
Okay. Okay. Let's pull that form out and look at it.
All right. I've got it right here.
Okay. I know you can't show it to me. I don't have it right here in front of me.
Well, do you want me to read it? Do you want me to read it to you what it says?
Yeah, go ahead.
Okay, basically it says, of course, you take their name. I hereby certify that I've completed the provided interview questions myself. My answers are truthful and correct. I authorize blank, or their staff to enter the information into the document templates on my behalf. Any assistance he or she is providing is solely a secretarial or ministerial capacity. She has not provided any legal advice or counseling and has not selected which documents I am purchasing. And then it's got the signatures, which I had both parties sign.
Okay, so what's the problem?
Right at the very beginning, to get in, the acceptance of the end user agreement. It says, the thing that you said, the thing that protects us is having the fact that the end user has to accept the agreement. But if I'm acting as secretarial ministerial and doing it for them, they, where is it that they have actually accepted
Well,
the
that's
agreement?
why you get the paper form signed.
Which I did.
Okay, that's what you've done. You've gotten your permission and you're fine.
Okay. All right. Well, good enough.
And those paper forms, if you get that paper form signed, just keep it in their file. Because
Well,
they gave you permission, and they said that those are their answers, and you shouldn't change their answers.
Oh no, no answers were changed, but just the
Yeah. So
I know
that's
I
just
didn't specifically read that. I didn't read them the end user agreement before I clicked accept.
okay. And that that written document that you have there says exactly what you need to have in the file.
All right,
Okay. Good
thanks.
question. Good question, Tony. Each licensee is required to read and agree to the presentation of this information to the end user. The presentation, like I said, is intended as a review and is not all inclusive of the end user agreement. You have to be sure that you have at least told the buyer that there is an end user license agreement and that they should read it. So, you're required to read it, and you're required to agree to the presentation of this information to the end user. Okay, and all we're saying is don't tell them you're an attorney, and don't tell them you're creating the document, and tell them that all you're doing is they are answering the questions that the attorney written software is asking, and that this software is a do-it-yourself software program. So stick, that's the truth. That's what, that's what you're actually doing. So are there any other questions? I thought there'd be a lot of questions on this one. So I just want to leave a little extra time. But if there's any questions out there, we'll try and answer them right now.
Randy,
Yes.
it's Jen. I don't exactly
Hi,
have
Jen.
a question, but I've done a lot of these agreement type things in other businesses and stuff. And that form is not going to cover it. But if you print out a copy of the end user license agreement and have them sign it as well, then that will cover it.
Okay. And again, that would be legal advice, Jen, and I'm not going to say yay or nay to that. That would be up to each person's legal counsel.
Okay, but
these
I'm trying
documents.
people not to get in trouble here, so that's how to
I
help
know.
people.
The biggest thing you need to be aware of is that this is do-it-yourself software, and that you are acting as an advisor, but you're not writing the documents. If they want to ask you questions, you can answer them as far as what you think is proper that you're licensed to do. But these documents have never been challenged ever, and they've always been upheld. Next question, but that's a good statement, Jennifer. And if that's what you want to do, it's okay to do. I think if we had to do it, I think Frank and Dean would be telling us to do that. Any other questions?
I have a question, Randall.
Okay.
So I was speaking with someone that they're a financial management group, and so they were saying that, a lot of their people are seniors, and if they have a question, is there an attorney that they can speak to if they wanted to speak to an attorney about a situation?
They are encouraged to, okay, I understand the question, Cynthia. They are encouraged to seek their own legal counsel. If you're out there working, if somebody has a question, email it to me and I'll send it in to Frank and we'll get an answer. That's why we keep an attorney here in Knoxville to have access to them if we need it. But the end user agreement is very clear. It says seek your own counsel. But at the same time, the majority of people don't need any other counsel. The only time that I usually go into it is if they're wanting a special wording on a beneficiary agreement, or if they have a specific question on whether the estate plan with a revocable living trust is appropriate or not. And sometimes it's not.
So who would it not be the best for? What situations? Do we know that?
Well, yeah, we did a class on that a couple of weeks ago, and I went over several of many different types of trusts.
Right,
You got to know
I remember that.
It's not a Medicaid trust, and some people who haven't read what they're doing will go out there and say, "Oh yeah, it's exactly what it is," when it's not. They might need an asset protection trust. They might need a just a special needs trust for a specific reason, although special needs is covered in our documents. But you know, as the advisor, you have to understand that the best thing for you to do might be to say, hey, this is not the right product for you. If that's what you think, send me the email, tell me the situation.
Okay,
We'll find the right person to give us that answer.
okay, great. Thank you.
Okay. Next question.
Randall Carter has a question in the chat. He said,
Okay.
is it okay to have them do the beginning part, then you start doing the data entry?
As long as you are entering their answers, it's okay. Don't enter the answers for them. Ask them the questions each time. Next question.
I have another
And
question.
then, sorry.
Go
Go ahead,
ahead.
Cynthia.
Okay, so if you are, once we do the family tree and we find out, who they would want to be their financial person or, the health person, those
Okay.
folks that are close to them, is there, particularly if they are not computer savvy, should we suggest that that person be a part of them answering the questions on the software with them?
The software
Rather than-
asks the question. Okay, Cynthia, the
I
software
mean,
asks
well, assist them.
I understand. All
answering
right, let me
questions.
answer it. Okay, so the software asks the question to the person making the purchase, and it has to be their answer. And you can enter it for them, but it has to be their answer because they are buying this do-it-yourself software program. So if they want to bring a family member in to help counsel with that, as long as it is, that's okay. But if it's as long as it's their answer, does that make sense?
Right.
And if you're going to be involved in it, you can review it. And when you're reviewing it, you're not giving legal advice. All you're doing is saying, is this answer correct?
Right.
So if they want to bring a family member in to help them make decisions, that's okay. But you just need to know that when it comes time for them to sign that document, that's their answer and it's going to be witnessed and notarized. Another question?
Hey, Randy, this is Barbara. Hi.
Hi, Barbara.
Hi. Hey, quick question. When somebody has an LLC, the funding kit talks about reviewing your articles of organization and seeing if you can, like if you have a partnership, if you can do that. But it talks about an assignment document. I'm not really sure what to do when they have an LLC, what we're supposed to do to get
Okay, well,
the
they
LLC
should
in
go,
this process.
they should either have an assignment document designed especially for their LLC, or they should contact an attorney to get one. That's not, we don't create that assignment document. If somebody says you have to have it, don't say, let me do that for you. Okay. So, but the minutes of their limited liability corporation will set out the rules. Sometimes the minutes of a corporation are just form documents. I guess that's the only way I know how to answer that question.
Okay, because I mean, I have an LLC too, so it impacts me as well, and I'm just not sure. Is it simply like a letter I put into my?
Well, I think if you have an LLC, you should contact your personal attorney and say, I want to put this in my trust. How does this need to be worded?
Okay.
So, if you know what that document is and you can find it online and you are happy with it, that's fine. But if you have any doubts at all, if that's going to be appropriate, then you can send what you have to us and we'll get Frank to look at it. but the ultimate responsibility of that being done correctly is not yours, it's the end user.
Okay.
Next question, but it's good to hear from you.
Felicia asked in the chat, "Hi Randall, do we need to say this to them? No guarantee."
Say that again, Lisa.
Felicia's message in the chat says, "Hi Randall, do we need to say this to them? No guarantee. Thanks."
Oh, you mean that no guarantee to future changes? That basically the way I understand that is that they're just saying that if you're if you have your document and you don't review it, and there are changes, it's up to the do-it-yourselfer to be aware that there are changes or that it needs to be reviewed. They're not going to if they do make a change, they're going to notify everybody, but they're not going to guarantee that the person who buys it will know about that change.
Legal change you're talking about, like
Yeah.
changing the law?
No, yeah, legal changes in law and stuff like that. So you know, there's no guarantee if you go to an attorney that you're gonna that they're gonna notify you if there's any changes. So the do-it-yourselfer has to be responsible. That's why you want to be in touch with an annual review. That's why you know, and if you have any questions, that's why you want to send it in, so that we can get an answer for you. But you know, because there's probably a million different answers to that, that's why they don't offer a guarantee. But who does?
So, Randall, my understanding is that if there is a question, we can send it in to you and you can get that question answered for us, possibly.
I will do my best to get that question answered. Most of you, when you send in questions, if I'm not totally swamped, we can get you the answer within 4 to 6 hours and sometimes 24 hours.
Okay.
And I send it straight to the attorneys that wrote, you know, that set up the software, and they have always answered our questions. Sometimes they say do it, some say don't do it. But as long as the question is properly worded, I can send it to Frank. And one of the questions I'll always ask you is if you have that question, type it up and email it to me, and I will forward it to Frank exactly as you ask it.
Yeah, because I think that's a comfort if people know that you're just not selling them something, but you are, you know, in place if there is a question. And, you know, will you tell them, well, before you submit it, let's do a review of everything so that, you know, if there's any
Right.
questions before it's
Cynthia,
finalized.
the reason I wrote the family tree, asset positioning, go-to first interview and the reason I ask you to do that in advance is because you are advising them on the thoughts and the process that they're going to need to answer when they do the software. That's why you want to do it ahead of time. Okay. So, you know, that's why I tell the story the way I tell it. That's why I encourage you all to follow the sales presentation, because you get all your information and the client learns everything they need to do before they go into the software. Okay. Doing it after the fact, after you sold them the software is not a good way to do it. Help them come to their conclusions before they go into that software.
Right.
Do the family tree asset positioning sales presentation, the go-to first interview, do it right and correctly every time.
Got it.
Next question.
May in the chat asks, by telling them to seek legal counsel, isn't that almost inviting them to end up doing business with an estate planning attorney?
Yes, if they feel like they need it, you know. But if you follow what I teach, and they understand what you're doing, and you use attorney written software, why would they do that? And if they decide to do that, they were probably going to decide that anyway. You do not discourage them you tell them that if they think they need to talk to an attorney, then they should approach that attorney and talk to them. You know, that's what the end user agreement says. You know, you're not, that doesn't belittle the software. That says the facts, that they're buying a do-it-yourself piece of software, and that if they have any questions at all, they are responsible for making sure that the document that they are putting together is appropriate for the situation they're in. That's not your call. But if you ask them about their family tree and ask them about their current estate plan and ask them about their real estate holdings and what their long-term care plans are and what their income is, and ask the health questions appropriately, and they decide that after you do all that, that they do not have the proper documents, and that if you and they agree that these documents in the family estate docs are the proper documents, they can go in and do it themselves, or you will be glad to help them enter the answers in. That's, you know, that's what you need to understand. You're not practicing law, and you're not claiming to be an attorney, and you're not creating the document. You're a coach. And once they have got their document set up, then you can go in and change your coaching hat and switch it to the funding process. But, you know, you are there to help them come to the conclusion that, yes, they can do this themselves, and that they do not need to go into the estate planning attorney. Now, I'll be honest with you, if their estate's in the multi-millions, they should go to an estate planning attorney. But if they're trying to design their plan to have the government pay for their health care when they're older, they don't need a revocable trust. They need a Medicaid trust. And when you do that interview, you need to be able to discern, if you want to use that word, DISCERNE maybe, or no E on the end, what the appropriate route is. And if you look at them and say, you know, I think you should go to an attorney, they're going to appreciate that. Any other questions?
Ed asked in the chat, so the docs would say my house is in the trust, but I still need to change the ownership from my name into the name of the trust, requiring an additional legal document.
That would be a quitclaim deed. Yes. And that's called proper funding, F-U-N-D-I-N-G, proper funding of the trust. And yes, you have to have another document. And nationwide, that price is about $300 on a retail level plus the registration. But you can do it through DeedWorks. You can do it through a local attorney. You might even do it through a title company. But, you know, we offer to do it for the client. And the client, that's what the client wants is service. You know, they want to participate in the design of the document. They want to answer the questions. They want it to be their answers. But at the same time, they want you to help them do it. And as they get older and older, they're going to depend on you to help them make sure that it's what they want. But you got to remember, these documents are answered by the client in a do-it-yourself format that allows you the opportunity to be their advisor and their coach on the financial end. Next question.
Felicia commented in the chat, I'm just curious how they are different from clients that go to an attorney.
How, when you say they are different, are we talking about the documents or the, help me out a little bit there. The end user agreement says that the software you're using is a do-it-yourself software package that is a whole lot more economical than the attorney. And you got to remember that you have a license agreement to make changes. You never have to pay the attorney fee again. You've got the do-it-yourself software, and you can go in and make the changes yourself. If you feel like you still need to have an attorney, by all means, contact one. But that's why you need to understand what you're selling, and they need to understand what they're buying. You're not selling legal advice. You're selling legally prepared documents that they have to be responsible for. And they want you to coach them through it, but do not answer the questions for them. Let them answer the question and you enter the answer in the appropriate place. I hope that answered your question. Any more questions?
Ed says in the chat, family estate docs is similar to the software the attorney or his assistant will use to write up the documents.
Absolutely. If not the same. There's lots of attorneys that use Estate Docs Pro and Family Estate Docs software. There's they use the same software. But they are sometimes they answer the question for the client. That's different. What else we got out there?
Nothing more in the chat.
Okay. The biggest question that I get when people want to become a licensee, they throw it out. How do you get around the unauthorized practice of law? Well, the way you get around the unauthorized practice of law is to not practice law. And you have a do-it-yourself software program that's attorney written, that asks all the appropriate questions. And if you do the family tree asset positioning, go to first interview in advance, then you have helped the client formulate the answers to the questions that they're going to be presented with. You're just doing an interview there. If you're insurance licensed, you're licensed to ask those questions. You have to know that because you have to put beneficiaries down on life insurance policies and things like that. So I hope that answered your question. Don't be afraid of this software. If it is attorney written. It is a do-it-yourself software package that, when done, needs to be properly funded. If you think of yourself as a facilitator, somebody who helps them learn what they need to know, and if they understand that this is a do-it-yourself software package, everything's fine. But if you presented it any other way, that's not fine. That's why I wanted to cover this topic today. I wanted to cover it with everybody's got any questions. Know what you're selling, know what you're doing. And Barbara, I appreciate your question. If you want to word that question to me in an email, I'll send it to Frank. We'll get you an answer the way that might help you.
Okay, thank
I
you.
don't try to. I'm sorry.
Oh, I just said thank you.
Well, you're welcome. Okay. Who else has a question out there?
Ed had a comment in the chat. An attorney will prepare a revocable living trust for $5,000 to $8,000, but our clients can get documents for $2,000, then take to an attorney to be reviewed for $500.
Absolutely. And we even can offer the review service, and we offer it for $250 because our attorney understands that these documents are strong. But yeah, if you want a review, you should always get a review. Estate Docs Pro used to charge $250 to $300 to have attorney reviews, and they got to the point where it was just useless because the documents are strong. But peace of mind is what you're looking for. So, and that's why we encourage people in the end user agreement that if you feel like you need to, it's appropriate to contact an attorney. And if your situation is extreme, that's exactly what you'll hear from me too. I'll say we need to go to an attorney on this. But if it's not extreme and if it fits the do-it-yourself software and everything is great, fine. If we need to do an amendment, we did an amendment last week on one. because of the unusual arrangement that they wanted for their beneficiaries. It just wasn't standard, so we had to do an amendment on it. Any other questions?
So for clarification, are you saying if we had a client that felt like they wanted an attorney to review the document or get an amendment because of their situation, like the special needs situation, that we could have someone on our team to review and make the amendment? Is that
Cynthia,
what
you're in Virginia or Maryland?
I'm in Virginia.
You'd want a Virginia attorney to do that.
Okay.
You wouldn't want a Tennessee attorney to do it. But first submit it and we'll get a ruling from the home office.
Okay. That's fair.
But always
Okay.
submit it. I mean, always submit it first.
Mhm.
What else we got out there?
Felicia commented in the chat how the clients
hi,
we
Felicia.
attract. So I'm not sure.
I'm sorry, say that
exactly what
again.
I'm not sure exactly what she means. I think she may want to ask, but she says how the clients we attract. So I don't know if she wants to elaborate on what she means there.
Please do. I'm not
Hi,
sure.
Randall.
Hi,
Yes,
Felicia.
hi. How are you doing? So what I meant is that the type of people that we attract to do this business with, how are they different type of mentality or what they are seeking compared to clients that go directly to a lawyer to do this work?
That's a good question, Felicia. And I'm going to just answer it the best I can. Okay.
Yes,
First
thank
of
you.
all, everybody approaches this problem from their own perspective, their own education history, their own knowledge base. And some people see an estate plan as a very simple formulation of wants and desires that can be documented and witnessed if the appropriate questions are asked. Well, that's what our software does. But then there are other people, and I've had people tell me, I think I need to go to an attorney. I don't do anything but agree with them because, some people have, they don't tell you the whole situation that they're in. That's why if you're doing the do-it-yourself questions with your client, they might have ulterior motives, and they may think that the software is going to let them do something sneaky. So each and every person's going to have a different approach to what's going on. That's why in the Family Tree Asset Positioning Go-To First Interview, I teach you all to approach people correctly by saying, I think you would benefit from a conversation with me about your current estate plan. You don't say you're an attorney. You just say you think that they would benefit. And then you go back and say, if we have that conversation, you will probably learn something in which you were not aware. And that's true. Now, if they're being honest with you and you talk to them about their family and their money and their long-term care plans and their income plans and their business agreements, it should come out in the open whether they need more advanced guidance and whether they need an attorney. But if their situation fits the software questions that you have and they're being totally honest with you and not trying to hide anything, you're going to be fine. So the people that you're going to attract to do an estate plan, in most cases, are going to be people that you think would benefit from a conversation with you about their current plan, not this one, about their current plan. Period. And then you can say there is do-it-yourself software that can help us answer this. This is what it costs. This is what we do, and it answers all the questions that you have given to me in the presentation. Is there anything you're not telling me? So the people that you attract to do this software are going to be the people that you select. And they're going to, like I've said before, they're on the other side of the river. And you want them to cross over and talk to you, but you got to get them to cross that river. And to do that, you build a bridge. And that bridge says, I think you would benefit from a conversation with me about your current estate plan. And if we have that conversation, you will probably learn something in which you were not aware. And that's true. Okay, so people are not going to be attracted just because you own the software. They're going to be attracted because you approach them properly. I hope that answers your question, Felicia.
Yes, thank you, Randall. I just want to get more clarification on the quality of these people. Like, I just want to make sure, I mean, who benefits the most from this conversation, and how do I know if I am choosing the right people to have this conversation? I mean, income wise.
Okay.
And
Okay.
so when I go there, I don't waste their time.
Okay. So the person that's going to benefit the most is the person that's open with you about their current plan. And once they find out that their current plan is not appropriate to their goals, is not congruent with what they want to have happen, then they have benefited and they're going to be attracted to your offer.
Mm-hmm.
There's going to be some people that have so much wealth and such complicated lives economically that you should say, hey, you need to go to an attorney on this one.
Mm-hmm.
Okay. I've seen people try to use a revocable trust as a divorce document. It doesn't work. Okay. I've seen people try to use revocable trust as a marriage document. It does not work. So, you have to be very, very clear on what the document does. And that's why you explain it in reverse. And if you listen to what I try to teach you all, if you explain it in reverse, they start and draw the family tree first. They start pointing out the people in that drawing that they want in those roles. And if they understand those roles, they don't need to pay the higher price attorney fees, and they don't need to pay an attorney fee every time they go in for a consultation. They will have do-it-yourself software that they can go in and change it themselves, or they can call you in to coach them through it. And it'll be appropriate every time. And they won't make a change unless it's a relationship change or an asset change or a health change. So there's a method in the madness. If you'll just follow the presentation that we teach, most of these problems get solved ahead of time. And then you offer the software, the do-it-yourself software, as a solution that is an improvement on their current plan. Does that make sense?
Yes. So what I'm understanding you saying is that it's better if they have already a estate plan in place then.
Well, everybody has an estate plan in place. Some call it a will, some call it a trust, and some people call it probate court. Everybody has a plan. If they already have a plan, that's only 50% of the population has a plan. And 80% of that 50% either don't understand their plan or are not happy with it. That means that 90% of the people that you approach are going to benefit from a conversation with you about their current plan.
Yes.
And whether they buy it from you or not, that's not what, you want them to buy it from you. But if they benefit from the conversation with you about their current plan, even if they decide to go to the highest priced attorney on the 12th floor in the New York City, Main Street, and they pay $30,000 for it, they've got what they want. And maybe it's worth it, maybe it's not. But maybe they didn't need the $30,000 plan, but the attorney knew they had the money.
Mm-hmm. All right. Thank you.
Mm-hmm.
Hey, Randy, I've got another question.
Go ahead.
Sorry, I just had a client actually call me during this call, and she's freaking out. So on her trust, the way it's set up is spouse one, as the trustees, is spouse one and spouse two are both trustees. And that's what they signed. That's what they agreed to. But now that she's funding her kit, the letters are coming out saying, spouse one, and she said, but shouldn't it say or, like spouse one or spouse two? And it's like,
well,
I don't understand
the
why
trust
she's asking
document
for help.
says whether it's both spouses or just one of the spouses. Okay. The form, if somebody wanted to prove a form, they would have to go to the document and see if the document says both spouses have to agree, or if one spouse can represent the trust without the other spouse being present. If the form's asking for two, it's because the form is not, it's not geared toward anything except what the trust says. So if one of the spouses signs that form and the trust says that only one spouse needs to be present, then it's fine.
Oh.
Oh,
So
what?
at the very beginning, and they agreed to all of this, but now she's going, but no, I want it to say or.
Okay, all right. So go back in and do a restatement real quick and just that one question.
But to do a restatement, isn't that like $200?
No, restatements are
No.
free.
Restatements are
Amendments
free.
are
Okay.
okay. Amendments are $200, but you got to remember your client has a license to use that software as many times as they want to for themselves and can change it as many times as they want to without any extra fee. All they have to know is what their login is and what their password is, and have a printer and a notary and some witnesses. But
Okay.
if they want you to do it for them, that's fine. I usually charge for the extra paper.
Okay. So to do the restatement, we would just go back to the interview review,
Uh-huh.
hold on, create your document. It's the trust provisions, and we'd want to check no, either spouse may act without consent of the other.
That's right.
Okay, gotcha. All right, I'll suggest it. If that's what she wants to do, fine, but otherwise, I don't see what the big deal is, but thank you.
Well, Barbara, people have good reasons and real reasons. And sometimes when they call you in a panic, they'll give you the good reason. And you might not ever know the real reason.
Yeah.
But again, that's why we say it's up to you to make them aware of the fact that they have to be responsible for the answers that they give.
Okay.
That's why you don't answer their questions.
Okay.
But you can give advice. You can advise her to go into that section and make that change.
Okay. Easy peasy.
Because you're smart. And you know what's going on. That's why they want you to be their advisor.
Okay.
That's where you can help. That's where you bring value to it. And then they'll write you a check next time they buy a $500,000 annuity.
Cool.
Or a $2 million life insurance policy. I hope that answered your question.
No, it really does. Thank you. And that's
Okay,
good to know.
okay.
It's not going to cost them extra to do a restatement. So awesome.
It's going to cost them some paper and ink.
Okay. If
Not
it's even
much,
worth
is
it to them to do it.
And now take that same document over to an attorney and see if you walk out of there $500 to $1,000 poorer. Let's do another question. Thanks, Barbara.
Thank you.
Andre,
Hey,
Andre?
Randy. Yeah. I got a good question for you. I think you might have answered it, but I just want to be clear, make sure I have the right understanding. So
Okay.
in Georgia, we're an attorney state like Virginia, and so I was looking up some information, and somebody mentioned to me about non-attorneys cannot offer legal document preparation as a business. And I heard
And
you
you're not,
mention,
right. And
and
you're not
I
doing
don't
that.
think that, right, because they're actually purchasing the software to do it themselves. And the answer would be is the fact that I'm just an advisor or a coach or consultant and helping them with what they purchased.
Right. And you're not designing the document, you're not writing the document, and you're not setting yourself out there as an attorney. Good question.
Correct. Well, yeah, but
I get it
I don't
about
think a
twice a
lot
month.
of these legal prep docs are not really drafting the documents themselves. They're using software just like what we're
Absolutely.
doing.
That's it. It's exactly what's happening. But if they have a law degree, they can give legal advice on their answers. If you don't have a
Correct.
law degree, you just have to record you can make sure they understand the question, but you have to put their answer down the way they say, and they have to know
Correct.
that they're responsible.
Correct, because in Georgia, you have to be part of or have some sort of education from the ABA or be a paralegal in order to do that.
Right, right. But you don't need to do that with your attorney written software because of the end user agreement.
Gotcha. Thank you.
Yes, sir. I got time. If you got time, any more questions?
Joe in the chat asks, when we make a business card and our business website and business brochure, can we use familyestatedocs.com and the phrase finding your true purpose for money?
Okay, Joe, I sent that question into the home office and they said, go for it if you want to. Finding your true purpose for money is not a family estate docs motto. That motto belongs to asset positioning services. But if you want to help people find their true purpose for money, it's okay with me if you use that phrase. Because that's what we do. That's what I do. I help people find their true purpose for money. It's okay. Yes. Now you can't, you have to pose yourself as a licensee for Family Estate Docs. You can't say you are Family Estate Docs, but you are a licensee for Family Estate Docs. So I think I would, if I was going to say Family Estate Docs, I would put underneath on the card, Joe O'Meara is acting as a licensee for Family Estate Docs, because that's what you are, a licensee.
Okay, thank you.
Yes, sir. And good morning to you. What else we got out there?
May had a question in the chat. Can we
Okay.
refer to ourselves as estate planners, estate planning consultant, estate planning software consultant, or estate planning done with you software consultant?
I think I would call myself a Family Estate Docs licensee. There are designations as estate planning. I work in the estate planning world as a registered investment advisor and as a licensee for Family Estate Docs. I would, if I was going to call myself something, I would call myself exactly what I am. So don't create a name. If you're an insurance agent acting as a licensee for Family Estate Docs, that's what you should say. Sometimes people think an estate planner is an attorney, but not always. Okay, so just be honest with who you are and what you're doing. I hope that answers your question. Any others?
No more questions in the chat.
We wore them out, huh?
But
Okay,
do
well,
you got
go
one
ahead.
question? Do you have any more round tuits?
I do. I've got about 700 more round tuits.
Okay.
And if you
All
want
right. I
some,
will yes,
let
I
me
will
know.
send you a text because I wanted to ask something I wanted to put on it and see if I can have it put on it. But
Okay. And
I'll send it
Cynthia,
to
what
you.
you have to do, well, just go to pens.com, PENS.com, and they will print on the back of that round tuit anything you want to put on it.
Okay.
The volume is what controls the price.
Okay.
I think I had to buy 1,250 to get the price. My wholesale price on that, I think, is 22 cents after shipping. I charge you guys a quarter plus shipping because I have to ship it twice, once to me and once to you. So
Okay.
I make about 3 cents on each one of those things.
Okay.
But you can order anything you want on the back of it. Some people like to put their own logos on it and their own business name and their phone number. I keep it generic because so many of you want to buy them that I just have to put a generic slogan on the back.
Got you.
But listen, people love them.
Okay.
All right.
Thank you.
Next question. Okay. Well, I think I've said all I can say about that. I'm going to give you about 10 more seconds. And listen, this was not a fun interview, but I just needed to have it with everybody so that everybody will understand what they're doing and how they're going about doing business. And this is a very prosperous way to do it. And it's a very legal and a very upright and moral way to do it. Just ask your questions ahead of time, not during help them come to the conclusions before they go into the software. That's what the Family Tree Asset Positioning Go-To First Interview is all about. That's the way it was designed, and that's its true purpose. All right. Any more questions going on in 10 seconds?
Ed says, thank you, Randall.
You're welcome, Ed. Anytime. And if y'all have any personal questions you want to send me by emails, randallbaxter@randallbaxter.com, I'll try and answer them for you. Other than that,
Right, Randall. I did find another source on the 3-ring estate planning binder that you can get one at a time and would you like that shared or not?
yeah, that's fine. That's fine. You can put it in the chat, or you can just tell everybody where it is.
Well, I'll just tell everybody it's of course, if you're an Amazon Prime member, if you just search padded estate binder, you'll come up with one, and it has gold. You got 6 color choices, gold foil on the front of it, and it ends at like $28 in hand in 48 hours or less.
Okay, that's cool, and that's good.
Would,
And I think
would you put it on the chat for us, please? So I can spell it right.
I don't have it pulled up. I don't have it pulled up right now. It was just.
Would you say it again, please?
Okay, just if you are an Amazon Prime member, just use the search term padded estate documents binder, and it'll be in the first 3.
And be
and like I
sure
said-
that Tony, does the binder have the internal pieces?
Yes,
The
I got it.
binder?
It arrived yesterday. It arrived yesterday morning. I actually ordered it on Saturday. It arrived yesterday morning. And I mean, it's, I had tried ordering somewhere else that I was 100% unsatisfied with. And this one is just as good as the one that I got from you initially.
Okay, and I'll admit I have to order 10 of them to get the price down to $29.
Right. And that was that's
the
the only difference. I'm not saying it's better. It's just that, hey, it is a very nice one, and you can do onesies, and they're fast turnaround.
Okay, cool. That's good information. Yeah, that's great
It
information.
is. Thank you. Thank you so much
Okay.
for that.
Listen, but I'm going to add something to that. Okay, Tony and Cindy, you ready? Increase your momentum so that you're ordering 10 or 15 at a time instead of 1, and your income will shoot up like a rocket. That's all I got to say about that.
I agree with you. I need
Okay.
that to happen.
Okay. Okay. Anything else?
May says, thanks, Randy.
Well, you're welcome, May. And listen, I hope this was helpful. I just wanted everybody to understand better what you're doing out there in the marketplace. And
It was very helpful.
I will give you an update on our last sale in our workshop. I think we're up to 4 estate plans and $390,000 in annuities and a $3,060 life insurance premium, and several more interviews to go. So I think that we're right now over a 6-week period, we have a profit on that one workshop of about $29,000 after all expenses are paid. They work, folks. I've always told you that I don't ever like to tell you to do something unless I've tried it myself. And that was the very first one I did, was one workshop, and made almost a whole week's pay. That's supposed to be a joke. You're supposed to laugh. Anyway.
That's a week. All right. Yes, my momentum needs to increase.
Listen, I've had lots of, I call it money days. I've had money days that are worth $29,000 based on the one-on-one approach to family estate docs. When you change that from one-on-one to one-to-many, the chances of it happen just multiply. So And I promise you, I would not be online here telling you to try it if we had not tried it and had not made it work. And it was not very hard. So anyway, the only difference in the presentation is we do the exact same presentation, but we apply it to many instead of one. We do the family tree asset positioning, go to first interview. All right. Anything else? I got one more
Mike
screen.
says,
Mike? What's up, Mike?
Mike in the chat said, thanks very much. Shooting straight like Randy does is the only way.
Well, I appreciate that. So here's my last screen. Thank you. And I'll let you guys go. I've got some work to do before I go home. Just like that poem, miles to go before I sleep, miles to go before I sleep. So take care, everybody. Talk to you next week.